How does New York State gift tax work? Transferring assets to loved ones during your lifetime can be a meaningful way to share your wealth, but it's important to understand the rules that may apply. New York residents often wonder if gifts they give are subject to state or federal taxes, and overlooking key rules can create significant financial consequences. Legal implications of gifting in New York. New York State does not impose a gift tax. This means individuals can transfer assets to others during their lifetime without triggering a New York-specific gift tax. However, there is an important legal caveat known as the 3-year clawback rule. If someone gifts assets and passes away within 3 years of making the gift, the value of that gift may be added back into their estate for New York estate tax purposes. This can result in unanticipated tax liabilities if the estate value exceeds New York's estate tax exemption of $7.16 million in 2025. If the value of the estate exceeds the exemption by more than 5%, the entire estate may become taxable due to the cliff structure. It's important to note that this clawback provision is effective through the end of 2025. Federal gift taxes, however, still apply. The IRS requires taxpayers to file a Form 709 if their gifts exceed the annual exclusion amount. Consulting an attorney with experience in estate and gift tax planning is a vital step to avoid penalties and ensure full legal compliance. Gift tax rules and limits. How much can you give? In 2025, the federal annual gift tax exclusion is $19,000 per recipient. Married couples can jointly gift up to $38,000 per recipient without triggering gift tax reporting requirements. Exceeding these limits doesn't automatically result in taxes, it simply requires reporting and draws from the giver's lifetime exemption, which is $13.99 million in 2025. Only when cumulative gifts surpass this lifetime exemption do they become subject to tax, potentially up to 40%. For gifts to non-U.S. citizen spouses, a separate exclusion of $190,000 applies in 2025. Some types of gifts, such as payments for medical or educational expenses made directly to the provider, and donations to qualified charities, are entirely exempt from gift taxes. Understanding these exclusions can help maximize how much you can give tax-free. A lawyer familiar with both state estate law and federal gift tax regulations can offer guidance on timing and structuring large gifts. What is the gifting process and how does it work? Gift taxes are applied when a person gives property or money to another without receiving equal value in return. Though New York has no gift tax, any gift made within 3 years of death may be pulled back into the estate under the state's clawback provision. To stay within legal limits, individuals must track the value and timing of their gifts. Annual gifts under the $19,000 exclusion do not require reporting. Gifts over that amount need to be documented via IRS Form 709. If a person exceeds their lifetime exemption, taxes are calculated based on a progressive scale. For example, giving $50,000 after using up the exemption could lead to a total tax of $10,600. Trusts can also be a useful tool in the gifting process. Irrevocable trusts remove assets from the estate and provide structure and oversight over how gifts are distributed. Tools like crummy trusts and grantor retained annuity trusts, GRATs, are particularly effective for high-value estates. An experienced attorney can help you choose the appropriate vehicle based on your goals. For high-net-worth individuals, estate planning should include strategies for avoiding the tax cliff and maximizing tax efficiency. Working with a law firm that understands both New York's estate laws and federal tax rules is essential. Secure your financial future and protect your loved ones from unnecessary tax burdens by speaking with the estate planning attorneys at Schlessel Law PLLC. Call 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States to schedule a consultation today.